Well, hi. Fancy seeing you guys here, shorties. Hello. I'm going to presume that you can hear me. I changed my top. I mostly had to change my dumb bra because it wasn't very comfortable. Hi, puppy. Want to say hi? Puppy? Say hi. Puppy, come back. Hey, baby. I'm a professional. Hi. Hi. Oh, God. What have I started here? Welcome, shorties. Oh, my goodness, Buster. Hey, fur baby. Nosy Rosie says, hey, fur baby. Let me just get myself organized here. I'm good. We're good. Poppy, goodness gracious. This is what she did to me yesterday. Can you see that? Blood blisters from being enthusiastic till the cows come home. I love you guys, but you're really a bit annoying at the moment. I know. I love you very much. Yes, two fur babies, Nosy Rosie. This is my world. No, Adam, I only changed because I just had to. I was getting all cramped. The migraine potential is very real. All right. So, shall we get started? Don't forget to like, share, subscribe. Poppy, are you going to like and share and subscribe? Poppy, please. Okay. Thanks. Hey, wait. I'm just going to get the dogs a treat. Wait, I'm going to put on. Oh, no, I'm not going to. Calm blue oceans. Guys, you aren't making the calm blue ocean thing very easy right now. Oh, my goodness. Welcome to my world. So, shorties, Donna Adelson trial voir dire starts Monday. Voir dire is French for jury selection. It's the process that all trials go through. Sometimes it's a prolonged process. Other times it's a much quicker process. But they have a jury pool, veneer, and they bring a whole bunch of people in, depending on how public how well known and how long the trial is going to be. They bring in X number of people to be potential jurors, and then they go through and Poppy, please, that hurts. You hurt me when you do that. I love you very much. They go through and weed out, for want of a better word, the hey Kenzie, hey Amy. Mia, weed out the people in the jury pool that maybe aren't the best fit. And contrary to some popular belief, they're not trying to curate a jury that is the most impartial and most open-minded jury. Karen Reid, take note, or not Karen, but Norfolk County DA's office and Norfolk Dedham Superior Court. They're trying to get a most balanced, open-minded, least biased, least prejudicial, fair for both sides, prosecution and defense, a jury possible. So that starts Monday. In the lead up to trials, there is always, and this is where the real work and the real the meat and potatoes of what happens in trial is in the pre-trial motions hearings. And if you were in on the Karen Reid pre-trial motions hearings, you'll know that you get to hear the inside scoop. You get to hear pretty much what is on the cards potentially to come to trial, to be presented to the jury, the fact finders. But not everything gets passed. Not everything gets allowed. So that's what we're going to look at tonight, and probably tomorrow night, because it's kind of fun. So if you're not up with or down with the backstory of this case, I have in the description box put a very brief outline of the case, but let me inform you, let me entertain you, let me fill you in for context. So back in July 18th, 2014, so more than 10 years ago now, beloved Florida State University law professor Dan Markel was shot twice in the head by two hitmen in his driveway of his family home as he just pulled in to get home. He'd just been to the gym. He was involved in a contentious divorce. Actually, the divorce had been finalized with his previous or ex-wife, Wendi Adelson. Spoiler alert, allegedly. She's in on it. Allegedly. This is all alleged, okay? So a contentious divorce, very much bitter. There was a lot of, as often is the case in child custody proceedings, a lot of underhanded stuff, disgusting, despicable things being said and threatened, and potentially, yeah, Adam, nice book, Wendi, yes. Potentially, just yuck stuff. It's going to all come out in trial. So it took the investigators, Detective Craig Isom, amazing, a little bit of time to start putting the pieces together, because it didn't seem that Professor Markel, Danny, had any or many enemies other than the Adelson family. Ugh, worst people. So there is Donna Adelson, ring a bell, Harvey Adelson, her husband. Then there is Charlie Adelson, again, spoiler alert, Charlie is already in prison, convicted in late November last year of first-degree murder and conspiracy to commit murder, and he is now serving life without parole sentence, LWOP, as we say. Amy, yes, Wendi is going to look cute in prison garb. So the way the cards fell is that back, I think it took about till 2016 before the investigators were able to get some leads on this, and they found a Sun Pass tag. They got camera footage, CCTV footage of the what they thought was the hitmen following Professor Markel from his gym to his home. And then they ended up starting to piece things together with a Sun Pass and a rental car that was rented, and it's all going to come out in trial. But basically, one of the now imprisoned hitmen, Luis Rivera, was in federal prison for a RICO charge. He's a Latin king. He was the head of the Latin Kings in Florida at the time. And but this wasn't a Latin king hit, right? So his best friend, Sigfredo Garcia, oh my God, this is such a convoluted story. His baby mama, Catherine Magbanua, was dating Charlie Adelson, the periodontist. Oh my God, he's such a fucking wanker. He's such a tool bag. Excuse my French, but we're going to swear. You know me. So she was dating him. And long story short, Charlie, the wanker dentist who likes to think he's the fixer, decided to, and I believe, allegedly, in collusion with the entire Adelson family, there's some contention over who was the actual mastermind. Was it Donna? Was it Wendi? Wasn't Charlie. He's just a putz. Who masterminded it? But regardless, Catherine Magbanua was the middleman. She asked her very shady baby daddy, Luis Rivera, Sigfredo Garcia, sorry, because he wasn't a Latin king, but Luis Rivera was. Ugh, the names. I probably should have like a cheat sheet. And they said, sure. So previously the family had offered, Donna and Harvey, and I don't know whether Wendi did, but they wanted Wendi to relocate from Tallahassee to Miami. Yeah. Miami, obviously. And Dan wouldn't allow it. He had a career and a very, he was beloved at Florida State University, so he wasn't going to move. And anyway, why would you? These awful people. They offered him $1 million, Dan, before he was dead, $1 million if he would allow Wendi and the two boys, to relocate to Florida. And then, in their mind, he was like, well, he can just fly whenever. What's the big deal? But he didn't take it. He said, over my dead body. Famous last words. So when that plan didn't work, my glasses are weird today. When that plan didn't work, I'm pretty sure what happened then is they were, well, fuck it. If he's not going to move, if he's not going to take $1 million, why wouldn't money just buy someone's compliance. I don't know. Well, let's go to hitmen instead. So there's so much. There's so much. This story is great. I have a whole playlist of shorts, like my entire channel, almost all of my subscribers because of this case, Charlie Adelson's trial. And like Georgia Kappelman, the state prosecutor, is queen. If you did we all, like if Lally tortured us all and droned and bored us and just infuriated us all into what the fuck with prosecutors, Georgia Kappelman will absolutely re-enthrall you, re-inspire you, give you faith that she is amazing. Like, she is amazing. Her co-counsel, Sarah Dugan, is also very good. So that's that. We then have Dan Rashbaum. So Daniel Rashbaum had never tried a murder trial at all. He was criminal defense, but not murder. He defended Charlie Adelson in his trial. Again, spoiler alert, that didn't work out too well. It may well be that Rashi, as we call him, is the Lally for this one. He's far more animated. He's hilarious with his this and that. He's also a renowned finger sniffer. I'm pretty sure he's a cigarette smoker, and he sits there in court, and when he's contemplating things, he sits there and you can see him smelling his fingers. So I think he's sniffing his cigarette, smelling his fingers. Oh, classy. So Rashi likes to say the reality is, that is Rashi's what if any. He also says, I don't think he's using the puzzle pieces thing this time around, y'all. Last time his theme was puzzle pieces. Anyway, their defense, Charlie's defense, and God, like, honestly, watch my playlist. It's hilarious. He's an absolute dick. There's lots of good stuff. Wendy's awful. Wendi is like, if you want to see yourself a robot, narcissistic, egomaniac, lying McLiar, if Wendi is talking, she is lying. She's disgusting. I can't even begin to tell you how much there is to this. It will all come out. So Wendi hasn't yet been charged. Okay, there's still more to say. Yes, hi, puppy. Wendi hasn't yet been charged. So Wendi has derivative use immunity, right? So Donna and Harvey didn't go to Charlie's trial, so thanks for that. They stayed away. Wendi was a state's witness. She had to testify. So she's a lawyer, mind you, an immigration lawyer, but anyway. And oh my God, you guys. Can we sit down, please? I'm trying to be a professional. And now I'm using my dog voice. Ah, puppy, that hurts. I don't want any more blood blisters. Please don't. Yeah, I agree. You guys are weird. You want to go outside? Hang on. Hold that thought. You want to go outside, you guys? Go outside. Go and do some outside stuff. I love you. Bye. Thanks. Thanks for coming. Thanks for your input. All right. So now they're gonna be like, "What do you mean we're outside? What? So Wendi was given derivative use immunity to be able to testify. Basically, what that means is anything she says on the stand cannot be used by the investigators or the prosecutors to file charges against her, to indict her. However, if they can prove with receipts that they that nothing she said was new information, then she can still be indicted. The thing is, Wendy's obviously as a lawyer, you can imagine why she wouldn't quite get the meaning of derivative use immunity, but she's of the opinion that she is absolutely free from prosecution, and this is the delusions of grandeur and entitlement that comes to with all proper narcissists and psychopaths. So excuse me. So she's testified in every trial. There was Luis Rivera was in federal prison. He spilled the beans, mate. He didn't care. He didn't want to go down for, like, he was a hitman. He wanted to just rob Dan Markel. He didn't want to actually kill him, but he had to do what his best friend's baby mama said, which was to kill. The Adelsons, it seems, paid about $139,000 cash, whatever Charlie had in his safe, for the hitmen to do their thing. So once he gave his proffer, Luis Rivera, in prison, federal prison, and was given immunity. He's serving, I think he's doing 19 years altogether, and it's consecutive. So, concurrent. So then he dropped Katie Magbanua in it. Katie and Sigfredo Garcia, baby mummy, baby daddy, went to trial together. Sigfredo was sentenced to life without parole in that proceeding, but the jury was a hung jury for Catherine Magbanua. Her case went to trial again, and she was then that time round convicted, and is also sending life without parole for her role in the murder. Next up was Charlie Adelson. The way they stimulated to some more evidence was to execute what was called a sting operation, where the FBI basically went in with someone undercover, walked up to, and there's footage out there, I'll play it sometime, not today, walked up to Donna Adelson, and she was walking across the street to go and pick up her two grandchildren from the across the road school that they went to, because after Dan Markel died, they did relocate to Florida. Handy, to Miami. Very handy. Imagine that. And walked up to Donna in the street, handed her a note, pretending to be a Latin king. Poorly done. He just did not seem to be like a Latin king. Anyway, to get them to see what then would happen within the people in the conspiracy. And of course, straight away, there was phone calls everywhere, calling this and that. They had a code word, which was TV, and that'll come out as well. But basically, Charlie Adelson used to joke that he thought about hiring a hitman to get rid of Dan Markel, but it was cheaper to buy Wendi a TV, so she bought him a TV. Again, this will all come out in the trial. But so Charlie went to trial. Wendi testified. Donna and Harvey were always going to plead the fifth, so they didn't testify in the trial. Charlie was convicted. Wendi impeached herself repeatedly, so that'll come. But as soon as when Charlie was convicted, things kept, there's these torturous jail calls between him and his mother, Donna, and within a week of that, his sentence being handed down, or maybe even his conviction, Donna and Harvey were arrested. Oh, Harvey wasn't arrested. Donna was arrested she was with Harvey at Miami International Airport with a one-way ticket to Vietnam, having researched non-extradition countries. So she was out of there. Sorry, I've got a short about that. It was so good. Pat Sanford. If anyone's ever seen Pat Sanford as a name in chat, Pat Sanford was the FBI agent who came out of retirement to make that arrest of Donna. It is absolutely epic. Oh my God, so good. So Wendi still hasn't been arrested. My firm belief, and I just know things, so my firm belief is that because she is under the impression, Wendi, that she has full immunity, and they need for her to testify in all of these trials because, oh, wow, just because she's a fucking train wreck, right? So as they did, like Donna, they probably wouldn't have arrested as quickly had she not been trying to flee. But thank God they did. And that was the best moment. I'm not going to lie. I was watching Surviving the Survivor back when I used to watch Surviving the Survivor. And I was there live when they found out that she'd been arrested. Glorious days. So good. Oh, the perp walk, the longest perp walk in history of her being. They were literally in the gang, the last bit of the tunnel right before you get on the plane. Oh, so good. Oh, so good. Like, oh, the joy I feel. So anyway, so here we are next. Donna's trial. Oh, friends, Ruthie. Who else have we got? Ruthie. I can't remember who are my other people who have been waiting for this moment for so long. This trial felt like it was being forever. And here we are. My firm belief is as soon as Donna is convicted for both the same charges as Charlie was done for, first-degree murder and conspiracy to commit murder, they don't need Wendi anymore. Then she'll She's TikTok, Wendi. Time is running out. Jetway. Thank you. Hey, Mona. Oh, hey, Mona. I haven't seen you for ages. Wow. Thanks for coming, gorgeous. Really. Thank you, Jetway. This is like I'm into hour 5 of live streaming consecutive at the moment. So if my brain is a little mushy, it's for many reasons, but that's one of them. So that's a real hectic rundown. We'll get there. The trial, Georgia is a master. Georgia Kappelman is a master. The trial that they're presenting, from what I understand in these pre-trial motions hearings, because I've watched them both. Thanks, Kenzie. Bye. Basically, they're presenting the same case because it's the same conspiracy. It's the same everything. There are some new things, and we'll see that. But I don't know how long you all will last, and I'm more than happy to go around 2 and even around 3. I don't think the trial will actually start with opening statements until possibly Thursday or Friday in the week, because the voir dire is I mean, it was a very highly publicized case. So it'll take them a while to select a jury. So here we're going to go. And like, when we hear Lally again and we're like, oh, like your brain starts to go, no, triggered. So it's the opposite with Georgia. Sweet baby Jesus. I love that woman. Like, I love her. Queen Georgia. There is on Facebook. I'll sell it to you, because there is a Facebook group called the Georgia Kappelman Appreciation Society on Facebook, not run by a person with whom I am no longer affiliated, and I will never be again. But it's a great page, and if you like, it'll be a great source of fun and information and speculation, a bit like the Justice for John O'Keefe groups on Facebook. So. I mean, I'm big enough to be able to promote the group and not buy into that shrew that runs it. If you know, you know, right? So let me see if I can do this. We'll watch a bit. We'll watch it on like 2x speed, maybe 1.25 speed to get through. And it's kind of cool. I'm going to be okay, so I haven't worked out how to do a split screen yet, but I can present, right? I can present the screen. So I don't have my earphones in, Adam. I'm sorry, Adam, my love and my tech guy. I didn't get a chance to pair my earphones. So I'm going to just mute myself. And I don't think I can bloody well pause from the StreamYard screen. However, yes, hang on, Poppy. I'll get 1 second, Mrs. Poppy. Where's the dogs? Let me put me here. So what I'm going to try and do, sounding very Australian there. See, look. So they're right there. I can't point. I just pointed with my finger. That doesn't work. That's not how it works. Can you see that? No, I don't think you can. I don't know how it works. I can point on the other screen. Right. Okay. So here we go. Wait. Let me do this. So that's Sarah Dugan there. Can you see my cursor? And I can't see the chat now. So this is Queen Georgia, and oh my God, she just gets more and more beautiful. She's on a winning. She hasn't lost any of these like her. That's Dan Rashbaum there, sniffy fingers, Rashi. In between is Donna Adelson, who is I think 72. Can't remember, and that's a new lawyer attorney. I can't remember his name because he's not in the band yet. We'll see. So right. Miss Shorty, lol. Queen Georgia wearing the green. It's a suit. She is like, honestly, 74. Thank you. Hey, Mona. Thank you. Oh, Mona, I'm so happy to see you again. I was just thinking about you the other day. Random. All right. So let's press play. And yeah, well, we're doing this. I'm a proper professional now. It's kind of cool, right? Make sure the volumes are. Oh, wait. Pause. I'm gonna go through all the. Sorry, I forgot to put my mic on mute. Sorry. Yikes, Lisa. That we are. Oh, let me turn on the Zoom as well before we get rolling.
Thank you, Judge.
All right. So let's just pause there. Y'all. Grandma Gotti. She's aged a little, huh? Sniffy fingers, yeah, right. Grandma Gotti, she has aged. She's got what? She was arrested in early December. And let's just say the blonde has grown out. She has put on some weight, and that's no shade. But I'm sure she's hating it. Prison food is not good for folks. Oh, hang on. I better let the dogs in. Wait. Hold that thought. Yes, dogs. Jeez Louise. Back off, you two. Lord. Okay, Adam, that's not even mine. I stole that from Jay. Shaming of Jay, says Grandma Gotti all the time. All right. So so far so good. Let's see if I can. Oh, so Judge Everett. Oh my goodness. Again, if we thought that Poppy, please, Lord have mercy. If we thought that Bev wasn't the best, Auntie Bev, Judge Everett is an absolute delight. I feel like maybe he's in the fucking Delight Club. Poppy, for goodness sake. Sorry. So we're going to love Judge Everett. I think he won the shit's just got crazy here. I think he won an award at the end of last year as like the best judge in Florida. Amazing. He's amazing. He's funny. He's glorious. He's beautiful. He's kind. He's patient. He's learned and knowledgeable. He's not Poppy though. Get out of it, Poppy. Sorry, guys. Dogs come first. Yes. No. Yes. Theoretically. All right. So let me mute myself again. I'm going to have to get headphones, Adam. Damn it. Okay. BRB.
Parties are onlookers. Beyond that, I will keep an eye on anyone who is attempting to enter. I do see one now for Shelley Markel as well.
Thank you, Judge.
For everyone who will be listening via Zoom this morning, you are not to interfere with the proceeding. However, you may listen to the argument of the attorneys and also the court proceedings as they unfold. Again, please do not interfere in any way with the proceedings. Mr. Rauschenbaum, does the defense have anyone that you anticipate joining via Zoom this morning?
No, Your Honor.
Very well. To go through the motions that we're going to hear today, we are going to address the state's motion in limine, the defendant's motion to use a jury questionnaire, the defendant's motion to suppress wiretap interceptions, the defendant's motion to dismiss the indictment for pre-indictment delay or to exclude evidence, the motion to hold the trial in courtroom 3B, and also the defendant's motion in limine. I believe the defense has also filed an additional motion in limine. Mr. Morris, if you can explain as to that as well.
Judge, we didn't first anticipate the court taking that issue up today, because I think the court's going to need information.
I muted it for a second. This audio is
based on
I'm
the
pretty
receipt
the audio in
after the deadline, the discovery deadline, if you will, for
one.
Mr.
feel like
Corbett's
just
presentation, which is 300 and something pages. Mr. Rashbaum was back and forth in terms of when we would get it and that sort of thing. We needed it before Sergeant Corbett's deposition, which was taken
Talking to the microphone.
Sarah,
Order of the day. Everyone who speaks, speak to a
oh,
microphone.
Melissa, I'm so glad.
Sergeant Corbett's deposition was taken in the midst of last week.
Love it.
And so the motion was filed immediately on the heels of that once we learned the information that was associated with
I
the
use
testimony
all
and
the audio and
presentation.
stuff for my.
Very well. As to that motion, I've not had an adequate opportunity to.
I used all the
review it.
audio for my shorts, and there was really no problem. The previous trial, Catherine McBanner's trial, was a bit dodge. The video is still playing. No, I paused it. Can you hear me now? Video audio is still playing. Jesus. Okay, fine. God. Lie. It's paused now. Jeez, you guys. It's paused now. You can hear me now. You can hear me now. Yeah, I know. Sorry, Colleen. Yeah, okay, now. I know. I'm still working this out. This is brand new for me. I haven't done this. Thank you. Thanks, Adam. Mwah. Perfect now. So the order is a bit dodged today. I'm pretty sure this isn't the courtroom that they'll be in for the trial. The one they're in has got like each juror, you'll hear, has got individual monitors. So different to bloody Dedham Superior Court. They have their own monitors. It's all, yes, this is the inaugural show. Trial and error. Thank you. You're good now. I just muted it on my computer, like as though that's going to make any difference. What an idiot. Anyway, here we go. Hang on. I'll mute myself. I'll press play and we'll hear this guy. So this is the new guy.
Need some time to prepare this as well.
I'm happy for it to be heard whenever it's convenient for the court judge.
So we can stay on our existing timeline of meeting the jury selection on the 17th. For now, let's tentatively schedule this for September 6th. Please consult with Lynn as to a particular time and courtroom. If I'm going to need additional time before we get to the 6th, I'll let you all know.
Okay, an issue with that? Okay.
Thank you. One other matter that I wanted to address as well before we get into the argument of the motions. Mrs. Adelson, previously I have addressed with you the fact that you are awaiting any conflicts as it would relate to the representation of Mr. Rauschbaum. Based on where we stand procedurally at this point, when you first gave this waiver, that was prior to there being any deadlines concerning discovery or being able to view the evidence that the state plans to present at trial. Now that there has been an opportunity by you to review this discovery with your counsel, I believe it is prudent to go through these factors again, ultimately to confirm that you still wish for Mr. Rauschbaum to act as counsel. If you please can stand and raise your right hand. Do you swear or affirm the testimony you're going to give will be the truth?
Yes.
You can lower your hand.
Y'all, she's in shackles. She's in cuffs and shackles. Is this not the best thing ever? Thank you, Sarah, in shock and horror for the new memberships gifted. You are amazing. Welcome and congratulations to anybody who got gifted one of those memberships randomly through YouTube. Amazing. Anyway, look at Donna. She used to be a stick figure. She's they're Jewish family, and Danny was a devout, well, as Donna liked to call him, a religious zealot. Not so much for the Adelson side of the family. In fact, at Wendi and Dan's wedding, Donna, he had his rabbi coming, and they're kosher, yeah, proper, they kosher, and they organized. Yay, Jean, hello. They organized for kosher food to be served at the wedding. And wow, at the very last minute, and unbeknownst to Dan, they changed it and served non-kosher food at this wedding. Ugh, despicable. Anyway, love to see you looking a little less gloriously styled and in prison jumpsuits and
Mrs. Adelson, you understand that you have, under the Constitution, a right to conflict-free representation. Do you understand this, ma'am? Do you also understand as well that one of your attorneys, Mr. Rauschbaum, previously represented your son in a case or a similar case in this matter?
Yes.
Do you understand that he has a duty to hold in confidence certain aspects of that representation?
I understand.
Do you understand as well that this could create a potential or actual conflict as it relates to your representation in this trial?
Yes.
As to that conflict, do you realize, or I should say, do you understand that this could affect your defense in some way?
Yes.
Have you had an ability to consult with other counsel as to whether you wish to have a conflict-free counsel?
I'm aware of it, yes.
And as to any potential or actual conflict that may exist with Mr. Rauschbaum's representation, are you waiving this?
Yes.
Thank you. You may be seated. And again, so it's clear why I'm doing this, ma'am, at this stage, as we move closer to trial, things are going to occur rapidly, including rulings on the motions that you filed, rulings on the state's motion, how this is going to affect the evidence, and how this will ultimately affect your trial. At any point, if you decide that you are no longer willing to waive this conflict concerning the representation, that's something that I'm going to need to address. Do you understand this? The defense counsel as well becomes aware before the next hearing that the conflict is no longer waived. Please bring this to the court's attention.
Yes, Your Honor.
All right. Let's go ahead and start with the motion that procedurally bears on whether the case will move forward or not. The defendant's motion to dismiss the indictment for pre-indictment delay. Mr. Morris, Mr. Rauschbaum, whoever is arguing this on behalf of the state, I'll allow you to proceed at this time.
Judge Manfred's lecture.
You may.
I got it right.
A+ for use of grammar. Go ahead, sir.
So, Judge, you read the paper, so I'm not going to go into too much detail other than what's said. I don't want to repeat myself too much, but just to point out a couple things. Here, there are two components that need to be shown. You need to show prejudice. We need to show a delay, first of all. That's clear. I think that's clear on the facts. The murder was in 2014. Donna Adelson was a suspect in 2016. An affidavit was released in 2016 showing she was a suspect. You'll see the evidence in this case. We've had an opportunity to review the exhibits the state intends to present is the exact same, pretty much, evidence that existed in 2016, that existed in 2019 in the trial, the first trial, Catherine McVanderwell and the others. So you do have a time delay. What we have to show is prejudice.
So before you continue as to that, and really all the details as to this matter, specifically, when are you alleging the first time is Ms. Adelson could have been charged?
She could have been charged in any time. She could have been charged in 2016, right? She could have been charged. They had affidavits for arrests of certain individuals that they didn't do in 2016. So she could have been charged in the first indictment of Catherine McVanderwell, Secreto Garcia, and Luis Rivera. She could have been charged at any point in time from there on forward.
The reason I ask the question is because the motion makes a reference to 9 years, but ultimately, when someone can be charged is when the clock starts ticking, at least by the logic of your motion, correct?
I mean, yeah, look, she could have been charged anytime after 2014, right? I don't know.
I wouldn't go that far.
I'm just saying, look, this is not, to be clear, this is not a statute of limitation. There is no statute of limitation.
There is none.
So we agree with that. But she could have been charged any time after the murder. But what's clear is that the evidence that they're using today, they had in 2016, right? Much of the trial in 2019, 2022, and 2023 is the exact trial that we're going to hear.
All right. Wait, what have I done? Oh, I've lost the chat. What? There it is. So another one of the Rashiisms is he says right all the time, right. The reality is, and right. Oh, good night, Nosy Rosie. Thank you for coming along. It is bedtime for a lot of you. Catch the replay, everybody, if you have to bow out, because this is kind of cool. Like the good stuff happens in the pre-trial motions. Yeah. Okay. What was an interesting point though? Wait. Where is it? Here, this. Who is the bigger pain in the ass, Donna or Sarah Boone? I mean, they're both murderers. They're both pain in the asses. Good question. Anyway, we'll keep going. Sarah Boone. Yeah, I'll be doing recaps at night because I have to do this peasant work shit every day of my life, as well as be a known YouTuber.
Here in 2024. So the only new evidence since then is her trying to get on an airplane to go to Vietnam, which we don't think is evidence, right? So essentially, their trial is based on wires that existed in 2016, emails that they had in 2016, text messages that they had in 2016. right? And they certainly had it in 2009. So 9 years is 9 years from, I guess, the murder, right? But if you're looking at it in any component, you're looking at what would fit under Florida law, under the 11th Circuit law, certainly a time delay, okay? So when you get that, then you have to look at the prejudice component, and you have to look first at the prejudice component. And you see here that because of that time delay, there are records that no longer exist that would show that she needs to defend herself against two of their main components of their case. So two of their main components of their case are going to be, and they're both brought in by Sergeant Corbett. Two of their main components of their case are call patterns, and I use the word patterns lightly, because in order to show a pattern, you need a length of time to show a pattern. So when they got call records, I believe, starting in May of 2014 through July of 2014. So they got a very short period of time. Because she wasn't charged in a timely fashion, call records showing that there is no pattern, that this is exactly what would have happened earlier, these pattern calls existed back then, but they haven't existed for years.
What was the retention policy for the phone service provider?
I believe it was 3.5 to 4 years. So that would take you back to 2019, give or take. And so we're able to not fully defend that point because the records don't exist anymore. That's prejudice. The second component are some text messages. So they have text messages where they claim.
Yes, Ruthie, blah, 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 Rashi. He does pontificate enough, but at least he has some inflection in his voice, right? I might speed it up a little more. I'll put it on to 1.5. Let me know if that's a bit too fast for you, but we'll be here forever if I don't.
It shows that she is outside of Charlie Adelson's house. We have to defend that. It's their one main piece of evidence. It's a premeditated crime to charge with. Is there one piece of evidence after the murder? There's very little piece of evidence after the murder other than that and the wires. So the way to defend that is through SunPass records. Those SunPass records don't exist anymore. Now,
what is the record retention on the Sun bill?
3.5 years is what we're told. And that's what Agent Corbett testified to at the last trial. So, Judge, it's a predicament for us, right? Because understand that it is clear that, by the way, before 2016, just a month after the murder, the state pulled financial records for Mrs. Adelson. Pulled all of her financial records. They pulled SunPass records for other suspects in the case. They pulled call records for other people in the case. They didn't do so for Mrs. Adelson, and now those records no longer exist to defend ourselves. Now, the second component is a bad faith component. I think the prejudice component is clearly established here. The bad faith component, it's important to know that under bad faith, you do not need to show a sinister motive. The law in this court is clear, right? United States v. Foxman, 87 F3rd at 1223 says that bad faith in this context does not require a subjective sinister motive on the part of the prosecution. That's important. Okay, we don't have to show that the prosecution did this on purpose. What we have to show is that they had a strategy, and their strategy was to wait. That was their strategy. Their strategy was to wait because they hoped that people would flip, and they kept on hoping that people would flip. They kept on hoping through the offers of immunity and otherwise that people would flip. And over time, they didn't flip. And so they waited, and because of that, we're put in a position where these records no longer exist. Now, Judge, we do argue in the alternative in this motion. And what we argue is if the court is not willing to dismiss the case, they should keep out arguments of and admission of these pieces of evidence. Now, we're not arguing that they necessarily need to keep out all call records, but they should not be able to argue that there's a pattern of calls. Because they can't establish a pattern because there's an earlier period of time that they have no idea what exists, and we don't have the ability to show it. With regards to the text message, we think it should be excluded. The SunPass records would clearly show whether Mrs. Adelson was at the house or not at the house. It would definitively show. Well, let me tell you why. Because you would see what SunPass records show back then, as they did now, is they show entry onto a turnpike.
Correct.
And so you would be able to see when she entered the turnpike.
Let me stop you there.
Yeah.
And let me stop you there. So Wendi, here's the thing. Wendi was so complicit in this. She drove up to the scene of the crime, and her interview. Well, yikes! She sat with Detective Craig Isom on the just literally hours after the murder, and for 5 hours, guys, friends who've been in back in the day in Roberta Glass's chat with me, we have listened to that and watched that interview ad nauseum. We might have to go there again for the new people, but Wendi, she drove all the way up and then she was like, no, I didn't think there was anything wrong. No, I just thought there was a tree down or something, an electrical storm. And George is like, well, was there an electrical storm? And she's like, no. You got to check out my shorts playlist. I've honestly compiled, I think it's 86 shorts of some of the best moments in Charlie's trial and some from Catherine Magbanawaz's trial also. Yeah. And Wendi Adelson wore the same suit to the first two trials, but her hair was different. She obviously forgot her straightener for the second one. So she wore the same suit for two. And we always speculated that maybe she wanted to make it look that that if her children ever looked back on the internet and that they would only see her testifying in one trial, spoiler alert, she's going to be probably testifying in her own trial as well. So anyway, let's keep going. Rashy. So much better on 1.5x speed though, huh?
Are there not methods to travel and avoid the turnpike points? But where it might not be as direct, it might not be as easy, where if you enter the turnpike here, you have an easier point of access to drive. But ultimately, could she have reached Mr. Adelson's home and avoided the sun-pass altogether?
Their record shows she did enter the turnpike. Their own witness shows that she entered the turnpike because he's got, on his many charts where he guesses, he's got her on the turnpike through a cell tower. So you don't have to guess that she entered the turnpike. You know exactly that she did enter the turnpike. Their own records show that she entered the turnpike at what's called the Dolphin Expressway. Okay? So you go take 95 and you get on the turnpike at the Dolphin Expressway. That's where Dolphin Stadium is. You would, first of all, see on the sun pass the entrance there. And their records show that she's on that. Their cell tower records show that. Okay? Their cell tower records show also timeframes on that same turnpike. Shows on their map, on their dots. They show her on the turnpike. What it can't show is if she got off the turnpike. It may not have shown her get off the turnpike, but it would show her get back on. So in other words, if they're correct, and she had gone to Charlie Adelson's house, which she didn't, but if they're correct, at some point she would have had to exit the turnpike. Okay? It wouldn't have shown her exiting the turnpike because when you exit the turnpike, it doesn't show you exiting. But they have her at a certain point in time back on the turnpike. They would have known when she got back on the turnpike and where. And that would have showed whether she was at his house or not. Definitively, it would have showed it. We wouldn't have to guess about it. It's just how the turnpike, it's just how the sun pass records work. It shows when you enter, and then it shows parts at the turnpike. So they're using a witness to make guesses. They have these beautiful charts where they have her pinpoint, and then they have Charlie Adelson's house. And they show that it could take from this time to this time, extra time. But they have no idea when she got off, where she got off, why she got off. And they would know for certain, 100%. We would be able to show for certain, 100%, if we had those records, whether she was at his house or not.
Excluding for one moment a future argument about Sergeant Corbett, why are these not right topics for cross-examination?
Judge, clearly if they're allowed in, they're right topics for cross-examination, but you have to do a balancing test. This is the premier piece of evidence in this case. It is the number one piece of evidence in this case, outside your house. Because it is the only piece of evidence in this case, other than the wires, that ties Mrs. Adelson to anything after the murder. It is the only piece of evidence. We have the wires speak for themselves. We have the checks that she wrote. We're not going to argue that she didn't write the checks. This is the only piece of evidence. And you're using conjecture to get it in, where if they had charged this case in a timely fashion, we would be able to show definitively she wasn't there. That's not our fault.
All right, let's go back to the U.S. Supreme Court case that is the genesis of this argument with Osco. I believe Justice Marshall goes through the role of the prosecutor and their duties, and also discusses how the prosecutor has an affirmative duty not to charge someone before they have probable cause, to thoroughly investigate the case, and also not to clog the court system with cases they cannot prove. What is your response ultimately to this discussion as it relates to this case?
I think it's a very fair question. I think what you have to do is you have to then look at what has changed. So in other words, in doing that, can't always be their answer, right? They can't just have a blanket answer. They have to be held accountable as to, okay, what has changed, right? And the reality is when you look at this case and you see what is going to be presented, you have the exhibit list. When you look at the exhibit list for this case and you compare it to the exhibit list in 2019, it is essentially the same exhibit list. 2019, the first trial. I'm not even talking about Charlie Adelson's trial. It is essentially the same exact exhibit list. Their exhibit list contains, essentially, against Mrs. Adelson, emails that they had back then, wires that they had back then, checks that they had back then. That's essentially their case against her. Okay? So the reality is, I mean, you're right. They should not charge people that they don't have probable cause for. But that can't always be their answer. They have to be held to ask, well, what has changed? You know, we asked a similar question in the last trial, and their answer was Dolce Vita. Okay, but Dolce Vita doesn't apply to Mrs. Adelson. She wasn't there, right? Everything that they had in 2000, and by the way, they had Dolce Vita, they just didn't have a clear version of it. The reality is you're going to see that 95%, probably more, of this case that we're about to hear is the same exact case as it was in 2019. Almost the same witnesses, almost the same evidence. It's the same case.
Any further argument?
No, Your Honor.
Ms. Stephen and Ms. Kappelman?
Thank you, Judge. So as the defense's motion states, the test here for is going to be whether substantial prejudice is caused, not just prejudice, to the defendant's right to a fair trial, and was it the product of bad faith so that dismissal is required. The two pieces of evidence that they talk about in their motion are the phone records and the sun pass. So I wanted to quickly go through each. For phone records, he says, well, there are call patterns between the parties that occur on major events during the planning of this murder that the state presents. But every time we present this evidence, we also concede and present the fact that the people in this case, they all have relationships outside of any planning for this murder. Their boyfriend, girlfriend, their parent, child, they have children together. Those people in those relationships talk every day. That's normal and that's to be expected. And all these people do talk every day during the time that we have these phone records. Every time we've tried this case, the defense picks a random day. This is every trial we've had since 2019, I guess. Every defense attorney picks a random day that summer and shows that, hey, there's also calls between these folks on these other days where there's not a trip to Tallahassee or some other big event in the planning of this murder to show exactly that. They've done that every time through cross-examination, and they do that without having prior records prior to May of 2014. So there's no substantial prejudice to the defendant, and there's no bad faith here. Law enforcement subbed records beginning in May of 2014 because they were trying to get records from around the time the shooting occurred in July of 2014. So a little bit before, and also we have records after. We have records leading up to 2016 where there was no murder being planned at that time. And obviously all of the parties in this case, as we established in the case, are still in contact. They're still talking because they all have those pre-existing relationships.
Before you continue, is there a reason the records that are at issue in this motion were never pursued?
Because those are the times around the June and July trips where there was the attempt to kill and the murder of Dan Markel. We have messages between them going back before that time, but we believed, or law enforcement believed at the time that they subpoenaed those records, that was the most relevant time to the information in this case that would be relevant to this case.
Were any further subpoenas as to Sunpass or phone followed up on once the state believed it did have probable cause against Mrs. Adelson?
I believe that after, so getting to the Sunpass records, the Sunpass records, we did, I think, try to get late last year once it came to light that, can I address the Sunpass records and I'll let you know kind of what it was? Okay. All right, going back to the phone records, though, this is not substantial prejudice, and it's not a situation, though, where the state purposefully did not indict Ms. Adelson until she could not get these phone records anymore. So there's no bad faith in this case. It's not a situation where we purposely didn't indict her so she couldn't get that. Moving on to the Sunpass records, first of all, there's no substantial prejudice that these records would be exculpatory. As the court pointed out, we don't know if there was a way she could have avoided that. We don't know if the exit or entrance even had a transponder in 2014. In fact, given that the defendant texted Charlie Adelson outside your house, and there was a witness at trial, Catherine McVanois, who said that the defendant had been at the house that night right before she arrived, we believe the Sunpass records could very well be inculpatory. And there's no bad faith here because we would actually like the Sunpass records too. We did, as the court asked, we had Jason Newland make a call to try to see if we could get the Sunpass records. I believe it was last fall in 2023, but we also learned that they don't have them anymore this far late in the game. But the bad faith portion of this is only satisfied when the government makes a judgment about how to proceed with litigation to gain advantage over the defendant, and as a result, the indictment is delayed. The reason we didn't try to get the Sunpass records earlier was because the state didn't really zero in on the fact that Donna Adelson went to Charlie Adelson's house the night of the murder until Catherine McVanois offered that information in 2023, leading up to Charlie's trial and at Charlie Adelson's trial. Catherine McVanois mentioned that Donna and Harvey Adelson had visited Charlie Adelson's house the night of the murder.
Before you continue, was this new information learned either through the proffer or trial preparation that had never come to light before?
Yes, we learned that from her through her proffer and through information that she gave leading up to trial and her testimony at trial, which was all in 2023. The trial being Charlie Adelson's trial in fall of 2023. Obviously, Donna Adelson's phone locations, have always been in the records. The messages have always been in the records, but we didn't zero in on the fact that, hey, that's where this cash could have came from. And that was this relevant to the money drop until Catherine McVanois said his parents had just been there right before I arrived. She said in her testimony that the money was there when she arrived, that it was damp. She believed Donna Adelson had washed the money. That made us zero in on the fact that Donna Adelson had been at Charlie Adelson's house right before she arrived.
Okay, so here's another thing. This family, they had 10, it comes out later, it's not going to be allowed at trial, and this is why it's helpful to watch these pre-trial motions hearings. But turns out that they had 10 million in their account at the time of the murder, the Adelsons, Donna and Harvey. But and Charlie Charlie had his money in his safe at home in stapled bundles, right? Bundles of $1,000 stapled together, top corner. And so that was one of the very incriminating and inculpatory factors, that the hitmen were paid with money that was stapled into $1,000 bundles. But also, when he gave them the money in a bag, a paper bag, and then I think in a plastic bag. But then when Catherine Magbanua and the two hitmen got the money out, it was all moldy because it had been wet. Turns out that Donna, we think, washed the money. She laundered the money, washed it. She didn't understand quite the meaning of laundering money or washing it, making sure it's clean. She thought that was a literal thing. And so the money had been washed and put back not quite properly dry, and then handed over to the hitmen. Lol, you can't make this shit up.
And that's when this money exchange could have taken place. After that, we began to look for evidence, that corroborated her statements. Leading up to trial, we found evidence in the phone records that corroborates the fact that Donna Adelson did go by the house through her locations, through the message outside your house. But this wasn't a situation where we waited to indict Donna Adelson until some past records were no longer available. We would like to have those too. The Foxman case says that the defense says that this delay had to have been a deliberate act to gain a technical advantage, and that's not what we have here. I'd also point out, Dan Rashbaum has said that he was retained in this case by Donna Adelson in 2016. Every trial that we've ever had has been, on YouTube, if anybody wants to see it, and they could have, if they believe that these some past records and phone records were so exonerating, obviously needed, those could have been requested prior to when they would no longer have been able to have been received.
Can the defendant, absent an active case of a subpoena of this nature?
The defense said in the last trial that he tried to get the SunPass records and he wasn't able to before we had even thought to try to get them.
Please continue.
I'm not sure when he tried to do that. Another thing here is that if the court denies this motion, I think at that time it would become right. The state would ask that the defense not be able to argue in opening or closings or testify in their own questions that, hey, because the defendant wasn't indicted until 2023, that means law enforcement or the state attorney's office didn't believe they had enough evidence. What anyone in law enforcement or state attorney's office thinks in this case is not relevant. Given that, we believe that, obviously the dates that law enforcement received evidence, the dates that, suspects were tried or convicted, those things are all fair game and can be pointed out by the defense, but not the argument that this delay was because the state attorney's office or law enforcement didn't believe there was enough evidence to convict.
So to summarize in a nutshell, the state did not even understand what it had in the way of a text message until Catherine McBanua was proper.
That Catherine McBanua's information that she provided to the state really made us zero in on that and realize that money could have been exchanged at that time by Donna Adelson to Charlie Adelson. And so obviously we always knew that they were traveling up to Tallahassee that night, the Harvey and Donna Adelson were.
After the murder took
Yes,
place.
sir. But Catherine McBanua's information that we learned after her trial, when she began to cooperate and leading up to Charlie Adelson's trial is what made us zero in on that.
Very well, thank you. Brief response, and then we're going to move on to the other motions.
Sure. Judge, I'll do the factual point first. I was retained to represent Donna Adelson in the late summer of 2016. Okay, so I think it was the end of July, beginning of August 2016. I was retained to represent Donna Adelson. The first trial happened in 2019. When that trial happened, we tried to get SunPass records. We did. We couldn't because we weren't an active party. We didn't have any subpoena power.
Well, you stonewalled by SunPass.
They told us, yeah, exactly. Okay. When we tried to get SunPass records again was when Charles Adelson was indicted in the case. Then we were able to subpoena and try to get SunPass records. We were unable to do so because they didn't exist. So let me be clear on that. Okay. All right. The first time we were able to attempt to get SunPass records, they no longer existed. Okay. Now, with regards to them, she makes a point that every council has picked a prior date. Let me tell you what happens. We did pick a prior date, but our universe for picking a prior date is like this big, right? And you'll recall at the last trial what happened with the prior date we picked, right? We are making prior dates. They found a court filing on that prior date. By the way, the court filing wasn't anywhere near the time of the calls, but they found a court filing on that prior date, and they made a big showing that this is another event, right? The reality is we want to find dates in 2013, in 2012, in January of 2014, in February of 2014. None of those existed because what they did is they got records only for a 4-month period of time. And any date that
as to that point, and I understand what you're getting at, but don't defense counsel in all manner of cases all the time say the subpoena was too wide, you cast too far. Meaning the murder, what led before, what led after, there's really not a lot of argument as to the relevance. But if the state is seeking records of your client, or hypothetically any defendant, going back years in advance, are they really permitted to do that?
They don't need to go back years in advance, but they're presenting evidence in this case. Let me make 2 points to that. First of all, they got financial records years in advance. So if they got financial records years in advance, why didn't they get the same cell phone records years in advance? What's good for the goose is good for the gander. If he thought it was good enough to get financial records that far back, get the cell records that far back. Number one. Number two, they're putting emails in this case back from 2012. Why not go at least back to 2012 or at least back to 2013? They just cherry picked a 4-month period. And by the way, the records she talks about that come on later, they're related to the bump. They're not related to anything else. They're related to the bump. So yeah, they created an activity, and of course, that's going to create another pattern, right? The reality is it's unfair because they're making a pattern argument that doesn't. If it was a science experiment, it'd be a false experiment. Their sample size is too small, and we can't counter it because the records don't exist. And we don't need to show that they did it. We don't need to show that they indicted her after the records existed. We're not claiming that that's what they did. They made other strategic decisions to delay her indictment, and those other strategic decisions had this consequence. And because of that, if you don't dismiss the indictment, you should not allow these records to come into evidence.
Do you have any response to the effect of the proffer as it relates to the messages?
Of course,
that was proffer, which was taken last year.
Of course, they had the message well before then. They had the outside your house message well before then. It's not listen. When I saw it in discovery, which was before proffer, I knew exactly what they were going to argue. It's very clear. You didn't need her crazy argument to know what they were going to argue.
Well, let's look at this from the aspect of bad faith. Is it possible in a voluminous case file to not know what this one piece of paper?
Sarah, no. Rashi is being paid very richly for this. I think he's probably already made $1 million. He will. So Charlie's defense was that he wasn't paying hitmen, that he was being extorted by these Latin kings. There was this massive extortion, excuse me, massive extortion plot, and that he was paying these extortionists in installments because he continued to pay Catherine McBanower, even though they broke up. They're only dating for a very short period of time, a few weeks, and that it was an extortion, not a murder for hire. So Rashi backed that because for $1 million, you will be pitching that. It was obviously Charlie's idea. The evidence does not support it. It flies in the face of common sense. So Rashi is a private attorney retained by Donna actually back in 2016, and then became Charlie's defense counsel. And then she's waived her right to what is it? She's waived because there's a conflict of interests. The fact that, like, if Charlie decides he wants to flip on his mother or on his sister, then Dan Rashbaum, has to recuse himself because he can't be involved in that because of the attorney-client privilege. So private attorney. So they also shelled out at the last trial $1 million for a voir dire, a jury selection specialist called Josh Dubin. He's a creep. He's disgusting. He just came in, $1 million from the Big Smoke from New York, selected a jury which was clearly not ideal for Charlie because he was convicted in under 3.5 hours. The jury returned a verdict. I think it was 3 hours, 20 minutes, including lunch. So Rashi will, he will dance on his head in the nude in front of Judge Everett if it's for another cool meal. Anyway, back to it.
What it actually means until a later date.
It is possible, but you have three, because there's been 3 prosecutors in this case, very fine prosecutors who have tried this case going into that case 2 times. So very unlikely. Very, very unlikely. That's what I would say. Possible? Yeah, anything's possible. But it's not that hard of a message to figure out. You have one of the key suspects in the case who you've got other records for, communicating with another key suspect in the case, who, by the way, in 2019, their theory was the same, that it was a murder for hire done by these 2 individuals. You have those, and you don't have many text messages between the 2. And you have one, and by the way, you only have 3 text messages on the day of the murder. And so it's pretty hard to imagine that they didn't think a text message from mom to son on the day of the murder, on the night when you're driving up outside your house, 10 minutes is the response, was not an important text message. I mean, if you believe that, I don't know, Judge. That seems a little, I'm skeptical of that.
Did they have the benefit, though, of the proffer until Ms. McBanower gave it?
They didn't have the benefit of the proffer, but you should listen to that proffer, because she doesn't talk about the outside the house message. And by the way, in that proffer, she doesn't even really talk about what they say she talks about. She did it on the stand, but she didn't do it in the proffer. That's not my memory of the proffer. She didn't say in the proffer that I don't believe that they had just left the house. That's what she said on the stand. They'd already put in the outside, they'd already marked that as an exhibit. So Judge, again, the standard is lower than what they're saying. Right? It's a bad faith standard, but it doesn't need to show that they purposely waited until after the SunPass records didn't exist anymore. We're not alleging that. We don't think that that's what they did. We think they made other choices that then made it. Look, at the end of the day, Judge, what it also is you get to do a balancing test. And it's a fairness argument. But aside from everything else, it's a fairness argument.
It's clear, but also rooted in due process.
Yeah, it's a fairness argument.
I'm going to reserve ruling as to this. Also, prior to making any ruling, I'm going.
So Pierre Harvey is, I'm sure, living his best life, free from the the clutches of Donna, the control freak, Grandma Gotti. I'd say when she was arrested in the jetway, it's great. I've got a short on it, but like, basically, she was even she's like, can somebody please make sure that Harvey walks out? I think she was worried that Harvey was going to keep the ticket to Vietnam and fly himself because they didn't arrest Harvey. So yeah, yes, Jeannie, he's still at the airport, lol. So, I mean, I reckon he's probably like taking only 30% of her calls from jail. I guess he can talk to her. He's, like Wendy's an unindicted co-conspirator. I can't recall. Does anyone remember? Is Harvey an unindicted co-conspirator too? Because if that's the case, I'm not sure whether they can talk to each other. Anyway, Harvey's either still at the airport, longest perp walk in history, bloody brilliant. Anyway, back to it. Let's see. I can't wait for Georgia. Oh my God, I love Georgia.
And review the trial testimony of Ms. McDonough concerning the outside your house text message, as I believe it does give context to what is being argued in the motion by both parties. All right, let's move on to the defendant's motion to hold trial in courtroom 3B. Mr. Morris.
Thank you, Judge. We've had a little bit of discussion about this previously. There are a couple of practical reasons. You're going to be the best judge of what occurred during Charlie Adelson's trial and the interactions with jury and gallery. Essentially, this motion seeks a prophylactic measure against that. You're great at controlling your courtroom and being able to interact with the audience and gallery.
But you still want a different courtroom.
Yeah.
Don't let me up. You're getting the point.
Fair enough. Judge, when we say counsel table there, the prosecutor's table obstructs the view of jurors 1, 2, 8, and 9. There's no ability for Ms. Adelson to view those jurors. There's no ability for the jurors to view Ms. Adelson or defense counsel. And of course, that's an important facet. Defense counsel sits here, displays here. Examining a witness, you park that at the prosecutor's table, of course. Disconcertingly, in the last case, there were circumstances where communications between counsel and the defendant are posted on the internet before the lawyer can even get back to their hotel. And so it's been interesting to read the media response. This isn't a circumstance of trying to curtail the media's ability to gain access. It's a function of trying to facilitate there are fewer opportunities for problems to arise. It's a practical consideration, and of course, all of this is in your discretion.
Well, I was going to say, in researching your motion, I did not come across a fundamental statutory or procedural right to be tried in a particular courtroom. Do you have one to argue today?
No, I do not. It's a due process argument and an argument of prophylactic measures to protect against. And then the last component, which I tried many cases in the courtroom, multi-co-defendant cases in the courtroom. All of them are different. The acoustics in this room are rough sometimes. But from the number of inmates that we potentially have testifying in the case and the movements of people,
Yes.
It's not my challenge. It's the bailiff's challenge. There are security issues. I know there's difficulty here. Courtroom 3B is smaller and more compact. I know that someone has mentioned that there are technological concerns of it being antiquated. No better time for us to ask court admin for an upgrade. We've got time to be able to put a machine in that works appropriately. There's really a functionality and a practicality argument to make sure that we best protect Ms. Adelson from things that we've seen occur previously.
Very well. What you raised about counsel table, when we do have co-defendant trials in this room, a second table is added as the defense's preference to ultimately have what would be considered as the co-defendant's table. And
asking that it remain in 3G is just from a practicality standpoint in presenting the case. In 3G, we have the big screen overhead. We have the multiple screens in the jury box for the individual jurors. We have an individual screen for the witness. In 3B, there's only one overhead screen that all 12 jurors will have to kind of squint to see. Also in 3B, the clarity of the picture on that overhead projector, that from the big screen, and sometimes the sensitivity of the USB cord that's connected to your computer are a concern. Sometimes the state has to actually, wheel a TV down in that courtroom to use.
Don't bring up that
Very
television.
inefficient, and I know
You
the court
know I
knows.
hate that television.
Right, it's a pain. And so, being in 3G isn't just something that we do for, or we've asked for. In this case, we asked for it in all cases where we have a lot of visual evidence to be shown. In this case, we have surveillance video, cell phone records, maps, text, emails, financial records with graphs and charts and electronic wire transcripts and other visual demonstratives that I think would be much easier for the jury to see and understand if the trial is in 3G. In the defense motion, they bring up, the inability to see the box that the judges already, or as the court's already addressed. They also bring up the lectern placement as an optimal. I routinely will move the lectern with the microphone over to the projector so that I can operate the projector, or have my laptop up here on the lectern so that I can use my laptop and have it on the big screen so that I'm still at the lectern and not, and can move it about. And I think that should solve their problem, the ability to move this lectern around. Finally, I just want to point out that, the defense is concerned about juror distraction. However, in 3B, the jury box is extremely close to the gallery. So I think that there's a risk for distraction there as well. And I think that the court in the last trial, through instructions to the jury and through, making sure there was no cell phones used, was able to remedy that.
Very well. Prepared to rule on this issue today. I believe as the final jury instructions make clear, the jury will be instructed that they are to decide this matter based on the nature and quality of the evidence presented. The court is going to take all means necessary to avoid there being any distractions from persons present, sitting in the gallery, or attempting to improperly influence the jury in some manner. The examples that were cited by the defense, the court is not taking lightly. At the same time, the court does not have a way to ultimately prevent what is being complained of in the motion from happening in any courtroom. I am going to be very diligent and also very thorough in the deployment of the bailiffs as it results in this matter. The court also will take all suggestion from the defense as it relates to the placement of the table, so the defendant can be clearly seen by the jurors throughout the trial. As to the placement of seating on the defense side, ultimately, any observers or onlookers in the gallery are going to be placed at least 2 or 3 pews behind the defense, so that way there can be no attempt to either photograph or record the defense's interactions with each other, with Mrs. Adelson, or attempt to get any snippets of papers or other matters. Concerning the media and also any onlookers, I'm really not going to get into why people wish to come, if they have a legitimate interest or if it's just a curiosity for them. The Constitution provides that the courtroom will be open unless there is a statutory or otherwise basis for closing the courtroom or excluding persons. The courtroom is considered open. However, the conduct of those persons, the court will closely monitor. Anyone who is acting inappropriately will be removed from the trial. If this even goes to the issue of contempt and trying to influence the jury in an improper way, believe me, I have no problem having them break out the handcuffs. You can ask around. The defendant's motion to move the trial to courtroom 3B is denied, and this is also for practical purposes as well. Courtroom 3G is the most recently renovated courtroom in the Leon County Courthouse. It has technology options that are unavailable in the other courtrooms, and it is also best capable of accommodating the needs of this trial itself. If the state can prepare an order or defense as to the denial. Let's move on to the defendant's motion to suppress wiretap interceptions.
Judge, I'm definitely not going to belabor this motion. It is the same exact motion that was filed in the last trial. It was denied in the last trial. The only difference in this motion is we have a section where it shows that Ms. Adelson has standing to make this motion. So Judge, I'm just going to rest on the papers. It's a preservation motion. We respect your judge's ruling previously, and I don't think, unless you want me to answer any questions.
I don't believe the state is contesting the standing of the defendant to raise this issue, correct?
Correct, Your Honor.
Does the state have any additional argument to make concerning this?
Judge, I do have a couple things I think I should put on the record, so we're not relying on your previous ruling in this case.
Go ahead. Well, as to certain findings or conclusions of law as to my review of Judge Hankinson's authorization, those to a certain extent I will be relying on, but I'll allow you to continue to make your argument.
Yes, sir. I just want to put a couple things on the record regarding the standard for, it's alleged in the motion that necessity is a standard, and truly that's not the case pursuant to Phillips v. State 346 Southern 3rd 1252. Exhaustion and the objective of the criminal investigation are the standard. And in this case, we have met that standard by showing that other investigative efforts have tried and failed, or too dangerous, or that this wiretap in this case was the most reasonable investigative technique under the circumstances. Regarding the objectives of the conspiracy in this case, the objectives of the wire in this case, it was to reveal the identity of the conspirators and their role in the conspiracy, so the structure of the conspiracy, and that's permissible. under McGuire v. State 307 Federal 3rd 1192. That's a 2002 case. So here again, we're trying to identify the persons involved and gather sufficient reliable evidence to prove beyond a reasonable doubt what their roles are, what's the hierarchy of the conspiracy, is there any additional physical evidence that can be gleaned in this case, any information regarding monies or assets or other things of value. Regarding the staleness issue that's raised in the motion, I did want to point out a couple things. We note that the issue of staleness cannot be solved by a simple application of numbers of days without consideration for the overall particular circumstances presented in this case. Here, the circumstances of this investigation required efforts that involved a lot of record gathering and waiting for records and receiving records and analyzing them before we got to the point where we had reached exhaustion and we're looking to seek a wiretap. The state subpoena served on 12/14/15 requested a bunch of records between 14 and 15. Those were received in 16, including this defendant's checking account. We then subpoenaed a bunch of different Adelson accounts that including the one that the checks came from, and those were not received until 3/1/16. So, that accounts for the timing. And there's a case that talks about, did I get it for you? Delay being appropriate in conspiracy cases or more leeway being given in conspiracy cases because of the nature of the investigation. It's going to take more time. And I think that is, State v. McGuire, and Judge, that's it's US v. McGuire, 307 Federal 3rd 1192, and that's 2002 case, which I already cited. Sorry to do that twice. But that case specifically talks about the government being entitled to more leeway in its investigative methods when it's pursuing a conspiracy, as it acknowledges that's a different type of case, different type of investigation. Lastly, Judge, I just want to touch on the issue of fresh evidence. As mentioned in the application for the wiretap, law enforcement anticipated the use of an undercover operative in conjunction with this wire because in doing so would produce the fresh results that chatter on the wire. And fresh new evidence among these co-conspirators. The chatter that occurred between them to handle the blackmailer was brand new communication that could only be intercepted using this wiretap. With this new evidence, the argument of stale probable cause becomes moot because the new evidence was being created at the time that the wire was up and the communications were being intercepted. And there's a discussion of this fresh evidence and the importance of gathering fresh evidence in US v. Maestas, Maestas, 2016 Westlaw 9725188. So that was all I was going to put on the record unless Your Honor had some questions for me or wanted me to put anything else.
No additional questions. As to the application for the wiretap, did the defense have any additional exhibits that were previously not provided during the Charlie Adelson motion hearing or for this motion?
No, Your Honor.
Very well. The court will file its written order in this matter. So let's move on from here.
Judge, can we just ask if there's exhibits be incorporated in the record here?
Yes.
Thank you, Your Honor.
All right, let's move on next to the defendant's motion to use a jury questionnaire.
Judge, the law says that it's discretionary. I think Judge Neff is doing one this week or this coming week, if I'm not mistaken.
Homicide?
Yes, sir. I saw some email traffic from Ms. Gaston with respect to it, but the objective is for jurors to come in, not talk about, hey, what do you think that we're here for, and what's your opinion on what we're here for, and let's discuss the case. And if we're able to have them.
So I'm going to maybe skip through this bit because they're just so the defense would like to do a jury. They would like to do a jury like a survey, a questionnaire to poll the jury so they can theoretically save on some time in terms of selecting a jury. The prosecution puts forward that it probably won't save any time, and not just the words that are the answers, the content of the answers is not the most important or the sole thing that's important in jury selection, but it's the demeanor of the person giving those answers, how they say them, and you just, as we all know, that stuff can often get lost in just text, in words. So let me see if I can skip through it because boring, and he denies it. Judge denies it. They'll be doing a proper jury selection as per previous trials with the same sort of questions. Have you heard of this case? Are you scared of the Latin Kings? That sort of thing.
And focus on the answers of the questionnaire. It could be made shorter, but the overall.
as a summary witness. I say summary witness because in the past she's been an expert witness, but I don't think she's an expert. That's issues in the case. They have the ability to pay the money either.
Was there
Of the Adelsons. They go through a bunch of accounts and they show what their combined wealth was. Judge, we think this is clear that under U.S. v. Bradley, that evidence of the defendant's wealth may be admissible both when relevant to issues in the case, but that use of a defendant's wealth to appeal to class bias can be highly improper and can deprive the defendant of a fair trial. Okay, this is clearly coming in for that purpose. Their wealth has no bearing on the issue in this case of whether Mrs. Adelson participated in a premeditated murder. There is no dispute in this case. We will stipulate it to it that checks were paid out of the Adelson Institute.
That was going to be my first question. And as to your general proposition, I would say you're correct on the law in the same way. The jury is not to consider that a defendant is indigent and hold that against them. It would equally apply to wealth. As it relates to the state's theory of the case, is there any relevant evidence of wealth that you're still disputing?
No. I mean, the argument in this case is that she paid for a murder, and that is not our dispute. I mean, we're disputing it was for a murder, but we're not disputing that she signed the checks. We're not disputing that the checks came from the Adelson Institute. And we're not disputing that $100,000 was paid to Catherine Magbanua on the night of July 18, 2014. We're not disputing any of that. We're not disputing that they have the ability to pay the money either.
Was there other evidence as to transfers of vehicles or other property that is alleged to have been given to Ms. Magbanua?
There's evidence of a car that was given to Ms. Magbanua that was in Harvey Adelson's name. We will not dispute that either. Again,
it's just generally, these are wealthy people, not the specific matters that are being alleged a part of the conspiracy or payment for the conspiracy.
we're not disputing any of that. So why do they need to show a wealth of millions of dollars? You know, they spend a lot of time on it, millions upon millions of dollars. What is that relevant to? I don't think it survives 401. But if you go to 403, it certainly doesn't survive that.
Response, sir?
Judge, this is a murder for hire. The state's entitled to prove that this defendant had the means to make the payments that are alleged, to make the payoffs that are alleged, to buy the cars, property, etc., gifts, etc., that are alleged to have been received by the killers. And it's relevant to show that they have the ability to make a $1 million proposed bribe that preceded the death of Mr. Markel. It's important to show the means relative to the payoff. So this was a drop in the bucket, right? That's important, I think, for the jury to understand the motive and the means and how this was executed.
Very well. As to this particular point, that will be granted in part and denied in part, as to evidence which specifically demonstrates that either Mrs. Adelson or one of the other co-conspirators used assets to pay Catherine Magbanua or other members of the conspiracy, the state is going to be permitted to demonstrate that evidence. As far as any general presentation, however, as to all assets of the defendant, that is where the line is going to be drawn. As to Mrs. Holt being examined on whether the defendant had adequate assets to otherwise participate in what would be called the $1 million bribe, or is alleged to be the $1 million bribe, the court will permit that. Again, just going into a general examination of all of their assets as to showing in some sort of way to create a wealth bias, the motion is granted in that aspect. If we need to get more specifically into which pieces will be used, we can do so. Are there questions as to the ruling?
May I have a moment to confirm?
Go ahead.
Judge, may I make something clear too that might help? We're not going to dispute the $1 million offer. In fact, we're going to bring it out. So that won't be an issue.
Yeah, I don't think they can hamstring us by stipulating things. We still haven't.
You don't have to accept the stipulation. I believe this much is clear as a matter of trial practice.
Let me just confer with counsel about the financial evidence and see if there's any clarifications needed.
Go ahead.
So am I correct, Your Honor, that if we're inquiring of the witness, Hull, about the time frame in which, say, the $1 million offer was being proposed, we would be permitted to ask the witness, what did you analyze, what did you look at, and did the defendant have the means to make that payment at that time? But we would not be permitted to say what was the bottom line in her bank account at that date.
Correct. That examination will be permitted. What would not be permitted is to say the defendant had $10 million at TD Bank on this date. I believe that's ultimately what the defense's motion goes to. Am I correct?
That's correct, Your Honor.
Guys, I thought it might just be interesting to hang on. Let me see if I can do this. Stop screen there. Wait. I'm a professional. So this is what Donna looked like. Night, Colleen. This is what Donna looked like when she was first arrested. Here, can you see that? So that was in November, early December, I think, last year. So that jailhouse baloney not working for her. Wait, can you, let me see. Wait. This picture here, can you see that? That one there? She was so mouthy and lippy to the judge in her first hearings, I guess, charging. I should know. It's been a while. Anyway, so that's what she looked like. Wait. Let's go back. Oh, haven't muted it yet. Wait, it's going to echo for a second. I'm getting it.
Okay, this one's a little bit more complicated.
Not as complicated as you think, but you may make your argument.
All right, so Judge, in the last trial, we filed a similar motion and you ruled in our favor. You excluded the hearsay testimony as being just that, hearsay testimony, okay? And what proceeded to happen, as we all know, is the state then asked the question of this piece of evidence, of these statements, to Wendi Adelson. Wendi Adelson denied that she ever said these things, and then they were able to backdoor it in through impeachment, okay?
Well, I wouldn't consider it as a backdoor as much as, would you agree with me, there are often times when it comes to evidence, may not be admitted for one purpose, does not exclude its use in other ways.
I would agree with that statement, but I would disagree that it wasn't a backdoor. But nonetheless, that was that trial. This is different because the question to Wendi Adelson in the outset, in that trial, was about a statement that Charlie Adelson made. So it fit an exception to the hearsay rule, which was, it was a statement of a party opponent, okay? In this case, the statement, if they ask Wendi Adelson the question in the outset, it doesn't fit such an exception. It's not a statement of a party opponent. Asking Wendi Adelson what Charlie Adelson said is still hearsay because Donna Adelson is the party opponent. And it's not a statement in furtherance of the conspiracy because none of this had to do with any conspiracy statement in furtherance of conspiracy to commit a murder. None of these statements are in furtherance of conspiracy. So what I'm trying to say in short order is, number one, you assume you're going to rule the same way, that it was hearsay, and prevent it from coming in through Jeff Lacoste. And what we're also arguing is that it should come in through Wendi Adelson because that is also hearsay. It's hearsay because it doesn't fit an exception. That it would have in Charlie Adelson's trial. It doesn't fit that any exception in this trial. And so we're asking that it not come in at all. Now, when you look at the statements, they're all a little bit different. Buying her a television was cheaper than a hitman, that Charlie Adelson actually looking to possibly hiring a hitman, and then that Charlie Adelson described the dinner as a celebration. That's even after the murder. So that's even, and then Charlie Adelson kept large amounts of cash in his home, right? These are all statements that are hearsay, right? They're hearsay if asked of Jeff Lacoste, and they're hearsay if asked of Wendi Adelson. And as a result, they shouldn't be allowed to be asked or admitted.
Response from the state?
I disagree, Your Honor. I think these are statements against interest. These are
Yeah, no,
statements.
I need to remove some people from the Zoom.
Yes, sir.
Go ahead.
And are in furtherance of the conspiracy, Your Honor. If Charlie is telling the main beneficiary of this murder that he's looked into hiring a hitman, that's in furtherance of the conspiracy, and how much it's going to cost, too, was part of the statement. That Charlie Adelson had, in fact, in the summer of 2013, begun looking into hiring a hitman to kill Dan Markel, and the cost was either going to be $15,000 or $50,000. One of the two, she said, as you will recall. How can that not be in furtherance of the conspiracy, right? If Wendi denies it, then it's textbook impeachment to call the person that she said it to indicate that she said it.
And that is your argument as to all four of the statements that are being highlighted.
Yes, Your Honor.
Well, I'll reserve ruling on this topic for now. I want to do some additional research as to statements in furtherance of the conspiracy. Let's move on to number 4. Testimony from Wendi Adelson.
And Judge, with regards to number 4, the state's position may or may not have changed on some of these. So I just want to let you know that at the outset. They let me know recently that their positions were possibly changing. So here we're trying to prevent certain statements, certain questions from being asked of Wendi Adelson based on relevancy grounds. So the first one is questions about her book regarding human trafficking. We can't for the life of us explain how that would have anything to do with Donna Adelson's trial for first-degree murder. The second one is Wendy's, the name changes of her children. There's never been any testimony that those name changes had anything to do with Donna Adelson. We don't know how that could have anything to do.
Okay, so within the children were starting school within, like, it was the end of summer, and one of the children was starting school, and Wendi didn't legally change their names until about 6 months later, but she did enroll the boys in school under Adelson, not Markel. So that is one of those little tidbits about how diabolical this bloody murdering family are, allegedly.
Again, with this case. The third is Wendy's willingness to allow Professor Markel's parents to visit their grandchildren since 2014. These statements have nothing to do with this case, and in fact are used to prejudice the jury against our client, even though it has nothing to do with her. And the fourth is, and it came up in the last trial, asking about the Florida grandparental visitation rights law. I think that is one that the state has agreed to not ask about, but they go back and forth, so I'm not sure. So, but I think that is one. Again, these questions have very little to no probative value, and they're done to prejudice the jury.
So the other thing they did was, Ruth and Phil Markel, who are no longer married, but they live in Canada. Dan was Canadian and had so they live in Canada. And after the murder, Wendi hightailed it out of Tallahassee the day of the funeral. Charlie didn't even go to the funeral, and I think Ruth and Phil Markel have only seen the boys, their grandchildren, in the decade since their son was murdered, a handful of times, 4 or 5, maybe 6 times in 10 years. And Ruth Markel found very quickly that she didn't have any there was no grandparental rights in Florida. So she went and petitioned and campaigned and had a bill. I don't know the words enough. I say I'm a law nerd, but basically changed the laws in Florida that grandparents do have rights when there's victims, not just as victims of crime and families of victims of crime. So they're talking about that now, that they don't want that that legislation to be able to be covered in court for the jury because it's prejudicial against the defendant, which, well, shit, yeah, motherfuckers.
And so under a standard of 403, they should not be allowed.
Sure. Well, also at one point with this line of questioning, I'll hear the state's position, but I'll make clear on this. I understand Ms. Adelson is a member of the bar. However, if any testimony is permitted on this point, she is not to be opining on the Florida statutes of the validity of. Is everyone clear on those?
Yes, Your Honor.
Go ahead, Ms. Kaufman.
I think in reference to the book, this is the one I kind of flip-flopped on because I went back and looked at how it came up last time, which was that Wendi Adelson denied wanting to relocate, denied being disappointed about losing her motion in court to relocate. And that is, of course, the state's theory as the main motive behind this crime was that she was wanting to relocate to South Florida. And I thought at the time that testimony opened the door to her having written a clearly autobiographical book about a woman just like herself, married to a man just like Dan Markel, who's utterly miserable and stuck in the place that she's living in. So if the testimony goes that way this time, I can't imagine a scenario where I might want to ask about that. I'm fine with approaching, if Your Honor prefers that, to see if we think we're there, where I can inquire about that. There's a high likelihood I might not want to inquire about it at all. So however you want to handle that one. In reference to the other 2 items, I think those go to the state's theory that this crime was done in order for Wendi to move to South Florida with these boys and to erase their father and his family from their lives. And there's a lot of evidence of that, and that's part of the failure to provide access to the children to his grandparents and the name changes. So these kids were 2 and 3 at the time, and it's the state's theory that the effort was to eliminate their father, not just physically.
Right. As to that point, Ms. Kaufman, I understand the relocation and the divorce proceedings as it plays into the state's theory, but ultimately, was it not Mrs. Adelson's right as the parent and guardian of the children to change names or make certain criminal decisions after the other parent has deceased?
Absolutely, Judge, but those decisions might be relevant to the state's theory in the murder. I'm not alleging that she's done anything illegal, but I think it's relevant to the consideration of whether or not this murder was done. It's inconsistent with what you would expect a parent to do on the heels of the murder of their father, right? So I think a reasonable juror could infer something from that and should be permitted to do so if they find it compelling.
Any further arguments on this issue?
No, Your Honor.
So just one briefly.
Go ahead.
Wendi Adelson is not trial. So, I mean, this may be a different topic if this were the trial of Wendi Adelson, but this is the trial of Donna Adelson. And what they're trying to do is they're trying to dirty up Donna Adelson based on decisions, either fair or not fair, that Wendi Adelson made. And again, that is, again, it doesn't fit, I don't think it fits the relevancy standard, but even if you get there, when you do a balancing test, they're going to be able to show, and they're going to do a pretty good job of trying to show what the divorce situation looked like and how Donna Adelson wanted relocation. I mean, they're going to be able to do that. So just adding this to the fire is, if in any way relevant, is when you do that balancing test, I don't even think it's close, Your Honor, for any of these good things.
Very well. As to subprongs 3 and 4 of number 4 of the defendant's motion of lenity, I will grant that as to prongs 1 and 2, I will give additional consideration to the argument that's been made on a reserved ruling as to those subprongs from them.
Thank you, Your Honor.
Let's move on to prong 5, jailhouse recordings.
So I think this is pretty straightforward, Your Honor. We're not suggesting that Donna Adelson's statements, whatever recordings they might use, and we have to look at the recordings, obviously, but we're not suggesting that Donna Adelson's statements don't come in, but Charlie Adelson's statements don't come in. It's hearsay. And it's certainly not in furtherance of the conspiracy. This is after.
So there's a bunch of like hours upon hours of Charlie calling his mummy in the week between when he was convicted and when he when she was arrested. So they're trying to, and there was calls before that as well. But so they're trying to keep out those jail calls because the hearsay rule is such that basically it can't be retelling of what someone else has said unless it's for the party opponent. So that means the defendant. So in Charlie's trial, they could use things that were said about Charlie. The prosecution could bring that stuff in. It can come as evidence. But because Charlie isn't on trial here anymore, the jailhouse recordings, that things that he said are hearsay. Yeah. So that's why they can't, they're trying to keep them out. But what Donna says is not hearsay because it's for the party opponent. See, I do know law stuff. I'm like a law nerd.
For his conviction. So we're only talking about, let me be clear, we're only talking about jailhouse recordings after Charlie Adelson is convicted. So there are recordings in this case that I believe the state intends to use, I don't know, where there is a conversation between Donna Adelson and Charlie Adelson. Donna Adelson, provided they meet other requirements, Donna Adelson's statements are not hearsay. They're statements of a party opponent. There's an exception to the hearsay. It's not hearsay. But Charlie Adelson's statements are just black letter law hearsay. They're not in furtherance of a conspiracy. It's after his conviction. I don't know how they could be in furtherance of any conspiracy. And some of the statements are inflaming.
Are any of these in any way tied to this issue of travel with consciousness of guilt?
Some of Charlie's statements, no, I don't think so. I think they're tied to, well, I think there are statements where Charlie is talking about his trial. And Charlie is talking about why he believes he was convicted. And Donna is responding. The way she responds, I think, is allowed in. She may then respond in part about travel. I don't know. I'm not sure what they're using. But Charlie's statements are not admissible.
Right. State response.
These are statements against interest that are made by Donna Adelson or are adopted by Donna Adelson in a conversation on a recorded line. We're not going to be able to extract one voice out of a conversation and only play half the conversation.
What is the subject matter that you seek to admit in this way?
Well, we're talking about a few things. One call is the open line call, which I think Your Honor will know what I'm referencing. Maybe you're going to have to listen to these, but there's a call where Charlie
application.
Yes, Charlie actually drops off the call. So we would want to play a few statements of Charlie just to show, like, this is what's happening. It's a call where he's dropping off.
Yes, Ducati girl, good point. So when Charlie was in jail, convicted, sorry, when he'd been convicted, and one of the times he was speaking to his mother, apparently jailhouse calls are notorious for, the line dropping out or whatever. And so she's on the phone and oh my God, they're just torture. We'll play a couple of them. They'll probably be played in court also, but, and then it drops out for a tick, and so Donna's talking, and there's two other people. One of them's Harvey, and then there's speculation as to who the other person was. But she doesn't hang up the phone. So she keeps talking, and she drops herself in it, mate. A hot mic moment and a half. So Ducati girl, I have a feeling that stuff's all in. That's in. It's not, but I haven't seen it being brought up here in these pretrial motions hearings. So that suggests to me that it's going to be straight up evidence, which is exciting because such a boomer, mad boomer.
He's, continuing to talk in the background. So I'm not sure if that's the one we're talking about or not, since Charlie's not really featured on that call. There are a couple other calls where the nature includes some of the talk of fleeing, relocating, committing suicide, and those types of things. So maybe those are calls that need to be provided to Your Honor to make a decision.
That would probably be best before I rule on this.
Yes, sir.
Also, as to this point, and I believe there already is a standard jury instruction as it relates at least to law enforcement and a defendant's interview. Is your argument essentially this goes to the context of the call?
Yes, context, admissions, context and adoptive admissions in some instances, yes.
Very well. I'll need to review these calls before I can actually make a ruling on, because as the defense has noted, this is a call between Mrs. Adelson and Charlie Adelson about the quality of the food at the jail. We have hearsay problems and we have relevance problems. Ultimately, I assume anything the state would be seeking to admit is going to be a relevance threshold from there, whether playing the entire context of it will otherwise get over the hearsay issue that I still need to determine. If admitted, though, this would be subject to a specific limiting instruction. I have given instructions in other cases concerning the use of context in a recording. I will read the sample instruction to the parties. You also may propose any suggestions if it is admitted. But ultimately, it would be, members of the jury, you're about to hear statements from co-conspirators or co-defendants of defendant. These statements are pertinent only to explain the reactions and responses they may elicit. You are not to consider these statements by any co-conspirator or co-defendant as true, but only to establish the context of the defendant's reactions and responses. That ultimately, if any will be admitted at all, that will be subject to that instruction to the jury. So it is clear, Mr. Rauschbaum, that nothing of a non-party is being admitted for the truth of the matter asserted. Right? Last prong, autopsy photos.
So, Judge, the Florida Supreme Court has held that autopsy photographs are admissible if they are relevant and not so shocking in nature as to defeat the value of their relevance. But to be relevant, a photo of a deceased victim must be a probative issue that is in dispute. Okay. In this case, there is no dispute as to Professor Markel's death or the means that he was murdered. There's no dispute as to that. In the last trial, and I might be wrong about this, I think I was kind of conservative, 10 separate exhibits, 2 X-ray images, 8 photographs. I mean, it's clear what the state is trying to do. We understand they have to meet their elements, and one of the elements is to show that he was killed. That has never been in dispute. We understand Old Chief. We understand that ruling as well. But, Judge, we would ask that these autopsy photographs be limited. That's our request.
Although I believe, I'm not certain if any of these were used during the examination of Mr. Rivera, but doesn't the examination of Mr. Rivera in some ways coincide with these photos, at least as to how the murder was carried out itself?
I mean, they weren't used with Mr. Rivera, I don't think. They were used with a medical examiner, and they were used in closing arguments. I don't know that, again, I think it's a balancing test. I don't think anyone's disputing how the murder was carried out. There's no dispute. I mean,
no, not that he was shot, but ultimately Mr. Rivera's details of what actually occurred as it relates to his credibility as a witness and explaining other aspects of the conspiracy.
We haven't done that in the past, but we're also we don't intend on attacking his credibility when it comes to how the murder was done.
So you may respond.
Judge, this is a material issue that the state's required to prove that the victim is in fact dead. We don't have to accept a stipulation. The photographs are what they are. We entered 8 photographs, which is relatively few for a homicide case. 2 of those photographs were X-rays, so not inflammatory in any way. One of them is an ID photo, and one of them is a photo of the sibling on the victim's arm. So that leaves 4 photos that are the type of autopsy photos that we think of as standard autopsy photos that show some gore. None of those are even internal. We're not seeing a scalp peeled back or the head open or anything like that. So I think this is a situation where we don't need to limit any further what the state has already chosen to introduce in this case.
Well, as to this point, I will find that the value of autopsy photos are probative. And the prejudicial effect does not outweigh them. The motion is denied as to this particular point. Let's move on to the defendant's motion to preclude traveler's consciousness of guilt.
So, Judge, I think our motion to some degree speaks for itself. In this case, the state went to tremendous means.
So when Donna, it turns out that Rashi was probably advising Donna to flee, that was her best bet. So we shall see whether Rashi's in trouble for that. I don't think he is, but basically he advised his client's mother that her best bet would probably be to try and get out of the country permanently. So there's that.
Means to try to wait to arrest Mrs. Adelson until she tried to step foot on an airplane. Their argument is going to be, we believe that suggests flight, and that the flight suggests a guilty mind or conscience. However, we cited some cases, albeit not in Florida. We were unable to find similar fact patterns in Florida. And we did cite the standard for the 11th Circuit in our papers, which spends a lot of time talking about the passage of time, which I don't think we need to reiterate again. I think we beat that to death today. But the cases are interesting. When I started to look at it, I was kind of surprised, but it got me thinking. And I'm not a judge, as you know, I'm far from it. But I started to think, if I'm deciding this decision, what am I really thinking about with consciousness of guilt? And I'm thinking, well, did the activity that the person did, can I imagine an innocent person doing that same activity? In other words, if an innocent person would have acted the same way, it probably doesn't go to consciousness of guilt. And I think that's a simplified version of those cases, those couple cases that I cited. And here, you can add that to the actual facts in this case, which shows that she wasn't fleeing. What you're going to see is that she didn't hide her travel. You're going to see that she applied for a visa with the State Department. You're going to see that she spoke openly to friends about it. In fact, friends booked her trip. You're going to see that she spoke to her lawyers about it. Okay, you're going to see that to make sure that she wasn't committing a crime. You're going to see that she used her own passport. You're going to see that her passport was in her own name. You're going to see that she booked a hotel. You're going to see that she went to her own airport. She didn't fly to Mexico or fly to San Antonio, walk across the border, go. You're going to see that everything was pretty open and notorious, things that would contradict flight. And so, yes,
does flight have to be surreptitious?
It doesn't, but when you're doing the balancing, again, it's all balancing, looking at the totality of circumstances. When you're determining whether it goes to consciousness of guilt, flight is a component, right? If for instance, it's surreptitious, well, that would be an argument in favor of the state as to why this would go to her consciousness of guilt. So the straightforward answer to your question is, no, that's not a requirement, but it's one of the balancing things when you're looking at the totality of circumstances. So when you look at the totality of circumstances here, you don't see surreptitious flight. When you look at the totality of circumstances here, you see that this is occurring many, many years, whether we say 9, whether we say 7, but after she's a suspect, you see that she's traveled many, many times and always come back, right? So, and by the way, you hear phone calls. They're phone calls, the ones that they're mentioning now, where she talks about it, and when she talks about why she's going and what she's doing, right? And so, look, consciousness of guilt is a very, this is going to be, I anticipate, one of their prime arguments in this case, and it's a red herring. And so it should be prevented based on the totality of the circumstances and looking at that 11th Circuit standard. I don't think there's much more else for me to say unless you have questions. But I'm here.
Well, is there any other evidence that puts context on this travel?
Is there any other evidence that puts context on this travel? I'm not sure I'm understanding what you're asking me.
Meaning, were there internet searches? Was there some sort of research about extradition?
Sure.
Are there things otherwise go to? This is not just the purchase of a flight.
Sure. There are pieces of evidence that I believe the state intends to try to admit that would show both discussion and possibly documentary evidence of looking at places where there are no extradition. Yes, there are evidence of that. One moment. Yeah, I will. There is evidence of that for sure. But again, that's part of the totality of circumstances. There's explanations for that also as to why that doesn't show that they're going to become fugitives and what was the actor's name?
Harrison Ford.
Yeah, Harrison Ford, running around in Southeast Asia for the rest of their lives. But we think that when you do your balancing test, prejudice outweighs. We'd also say this, and this, my colleague brings up this point. It also leads to a variety of other issues. They have an appointment book, for instance, that they recovered when Mrs. Adelson was arrested that talks about a Vietnam villa and payments for a Vietnam villa, right? Well, that can be taken out of context as well. That Vietnam villa is an investment done, as they know, they've spoken as their witness, we've deposed them, with an individual named Scott Radius, who lives in Singapore. That individual had an investment with Charlie Adelson in a villa that, by the way, is sand. It isn't even built, and when it is built, they can spend 6 days in it. That villa.
That's under the rules of Vietnam.
No, it's like a timeshare. So even when you own it, you can only live in it for 6 days. And so when Charlie Adelson is arrested, Donna Adelson and Harvey Adelson continue to make payments for that villa because that's the agreement they have with Scott Radius. And if not, they lost the prior payments. It leads to, look, this consciousness of guilt argument leads to a lot of nonsense, to be honest with you. And we think that
No, Rashi. What's nonsense? Sorry for the dirty pause, Rash. What's nonsense is suggesting that purchasing a one-way ticket to Vietnam, having researched countries that have non-extradition laws, treaties in place, would not be anything other than consciousness of guilt. Silly little man. Silly little man. Oh, Rashi, honey, I ate the kids. Michelle, that's awesome. Good one.
when you do the balancing test of the totality of circumstances, that it shouldn't be allowed in as consciousness of guilt. And at a minimum, if it is allowed in, we'll probably ask for some sort of limiting instruction. But Judge, we think that it does fit, the case law. Nothing binding on this. I mean, I think the case law of the 11th Circuit is very clear. It's in your discretion. But we think that given what they've done and the importance of this evidence to them, we think that when you do the balancing test, it fails. So.
Judge, there are just as many factors that suggest that this was, or flight was, a matter that was demonstrating consciousness of guilt as the ones that they plan to argue. She was just going on a vacation. She got an urgent emergency visa and bought a one-way ticket to what she had researched to be a non-extradition country. The state feels that's relevant. If it's anything that the defense wants to argue and the facts that they pointed out are the fair game for cross-examination, they are free to elicit those, and we can have a dispute. Let the jury decide what the evidence shows and what the weight is rather than the admissibility. But how is it a 403 problem if she's just going on a vacation and that's what they're going to show? What's the prejudice if she's just going on a vacation? Problem for them is that there's plenty of evidence showing it wasn't just a vacation, it was something else. There is evidence of fleeing, and that's what we're entitled to show.
As to this motion, I am prepared to rule. I review the cases cited by the defense within its motion, and also looking at this as a matter of weighing prejudice versus probative value. The motion is going to be denied. I do believe this is a matter that goes to weight versus admissibility. The finder of fact, the jury, is going to determine whether Ms. Adelson was in fact merely researching a vacation, or if she was in fact seeking to avoid prosecution, or this is consciousness of guilt. Really, it's not for the court to exclude, as it is relevant and probative. As far as any limiting instruction that defense would seek, you may submit that concerning this issue. Right, I believe that covers the defense motions for today. Rob, if you can submit orders, at least for the matters that have been ruled upon concerning these matters. Let's move to the state's motion in limine. As to prong one, Ms. Kappelman.
Yes, Your Honor. As we have done previously, we are moving to exclude Mr. Rivera's affiliation with the gang and any specific prior bad acts as irrelevant and bad character evidence. Did you want me to address prong one?
Just prong one for right now.
Okay.
I believe at least in the prior trial, this was granted in part, denied in part, specifically as it relates to the defense being able to cross-examine on the issue of bias as it relates to any plea. Are you aware of any authority that would otherwise suggest this is an inappropriate ruling?
No, Your Honor. I anticipate Your Honor would make the same ruling.
Very well. Does the defense have any argument to make as to prong one?
Well, I mean, I think we're going to have to bring up the Lion Kings. I mean, they inserted it. We weren't able to make this argument in the last trial. His affiliation with the Latin Kings is very relevant as to why and how Mrs. Adelson acted.
Well, I believe it did come out that he was affiliated with a gang, did it not? It's just the name Latin Kings wasn't used.
Yeah, I mean, I just don't want to go afoul of the court's ruling, right? The fact that he is the head of the Latin Kings is a relevant fact. That was actually inserted by the state in their bump operation, right? The whole point of the bump is someone's approaching Mrs. Adelson, who is supposedly also a member of the gang, and is speaking on behalf of Mr. Rivera, who wants to get paid, right? And so part of the reason why Donna Adelson acts the way she does and talks the way she talks is because of Mr. Rivera's affiliation with the Latin Kings. I mean, I don't see how we avoid that. Now, as far as his bad acts, I don't plan on going into, just like I did in the last trial, how many murders he's done, how many rapes he's done.
So the name of the identifier, that is what you're seeking to make use of.
Of course.
Ms. Kappelman, response as to the use of the name of the group.
I do not agree that the name is in the evidence that the state intends to produce. If that's Your Honor's ruling, which we would request, then criminal street gang could be substituted for Latin.
Judge, we would disagree with that. I mean, there's a difference between being a member of a street gang and being a member of the Latin Kings. And when Ms. Adelson hears that the guy...
As one gang has greater credibility than the other?
It certainly does in Miami. right? So when Ms. Adelson hears that the Latin Kings are behind this, and that's what she hears at some point, that's what the evidence is going to be, it affects how she does certain things, right? And so, we think that is relevant, and that is necessary for her defense.
Very well. As to prior bad acts of Mr. Rivera, the motion is granted. I will also once again permit the defense to explore Mr. Rivera's bias in connection with his plea and any sentence that he has received. As to the specific affiliation with the Latin Kings as being a relevant or probative issue, that goes to explaining the defendant's actions. I'm going to reserve ruling as to that. Specifically, again, in what context beyond hearing she knew he was a gang member, or are you planning to use this or present this to the jury, Mr. Rashbaum?
So if there is testimony that she heard he was a member of the Latin Kings and she reacted a certain way, I should be able to confirm with him that he is the head of the Latin Kings. That's it.
I don't think it's a 501c3, but this was a particular chapter that he was in charge of. Is that what you're getting at?
Correct.
Ms. Kaplan.
We just think it's prejudicial, more prejudicial than probative. We don't think the evidence is going to support that she knew he was a Latin king. She knew there were gang members that were threatening to kill us, what the evidence showed in the last trial. So I guess we'll see how things develop. I would request that if the defense thinks the door has been open to that, we approach before they start throwing around the term Latin king.
All right. Generally, as to the issue of Mrs. Adelson conformed her behavior or acted in response to what she believed were the threats of a gang member generally, I will permit that to be offered as a part of the defense's case in chief or any cross-examination. Specifically as to the use of Latin Kings, I'm going to reserve on that issue for now.
And so, Judge, just so I'm clear, before we ask any questions with the words Latin Kings in it, we will approach.
Correct.
Thank you.
States, prong 2. I believe there is no objection on this issue.
No objection, Your Honor.
Prong 2 is granted. Prong 3, Ms. Kaplan.
Yes, Your Honor. Prong 3 relates to Mr. Rivera's mental health status. This has been excluded previously. To reiterate, there's no evidence of Mr. Rivera's mental health condition affecting his testimony at any of the previous trials, nor do I have any evidence that he's suffering from any mental health symptoms currently that may affect his upcoming trial. Obviously, if that changed, I would notify the defense and the court. And there's no evidence that he was suffering from these symptoms at the time that these events that he's testifying about occurred. So I would move to exclude any evidence or mention of his mental health conditions or diagnoses or symptoms.
Response?
We don't plan on doing this unless something crazy happens in court. Then we'll approach Your Honor and we'll discuss it then. But we don't plan on practically talking about this trial.
Very well. Prong 3 is granted. Counsel for the defense is directed to alert the court should you believe the door has been opened in a material way concerning this issue. As to prong 4, is there any dispute as to this prong?
No, Your Honor. We've asked for the same courtesy with regards to our investigator, and they've agreed as well.
Prong 4 is granted. Prong 5, is there any dispute?
No, Your Honor.
Prong 5 is granted as well. As to prong 6, is there any dispute?
No, Your Honor.
Prong 6 is granted. As to prong 7, the demonstrative aids, Ms. Kaplan, you may make your argument.
Yes, Your Honor. The state has prepared demonstrative aids, which combine video footage, clarified audio recording, and transcripts into one item that we'd like to present to the jury for both the Dolce Vita recording as well as the Matsuri recording. Those are mentioned in paragraphs 4 and 6. We also have similar to what we've used previously with the wiretap calls, slides that have this rolling transcript along with a photo of who's speaking, which we think assists the jury in understanding those items of evidence. I think that was all that was covered in these. Yeah, so Dolce Vita, Matsuri, and the wire calls. We did previously have an objection to any editing, any underlining or any highlights, which we have removed from those exhibits. So this will not be present.
Well, response?
Our position is the same as in the last trial. We don't object to the transcripts from the wire. We do object to transcripts for Dolce Vita and Matsuri due to audibility. And last time I think the judge ruled with us and ruled that the transcripts would come in for the wire, but not for Dolce Vita or for Matsuri, and that's our position today as well.
I reviewed the recordings of both Dolce Vita and Matsuri once again. The issue that I keep coming back around to on this, Ms. Kaplan, is ultimately for a recording that does have some limitations or issues. How does the transcript not otherwise suggest to the person, or jurors who need to listen to and interpret it, what is on the recording if they themselves are not able to make it out clearly?
We do have and had in the last trial as well the authentication of the transcript by a party who was present for the conversation. I think that's what made the difference in reference to the Dolce transcript use in the last trial. We were able to use that. Matt Surrey was out, the defense is correct on that. That could potentially
Is that witness going to authenticate then the transcript itself?
Yes, Your Honor.
Mr. Fleischbaum, any arguments concerning them?
Yeah, you still can't hear tons of the transcript, and they're guessing as to words on tons of the transcript, and you still can't hear the first 31 minutes because they didn't record it. And they have a recording of those 31 minutes, but they didn't include it. So it should be, look, the standard is in situations like this, you leave it up to the juries to hear what they hear. We're actually not moving to preclude the audio, we're precluding a transcript, right? The law is pretty clear that it's up to the jury to hear what they hear and make a decision based on that and not what the state thinks they hear.
I agree with you, that aspect is clear. The additional portion of the witness who will swear that the transcript is authentic. What is your argument to that?
But every other word of the transcript is unintelligible. UI. So, that should not come in. You can hear some of those UIs. Sure, I can cross the witness, but do we really want to go through that when it's very easy that they just hear what they hear? That's the default.
Very well. This will be granted in part and denied in part. As to any transcript for Matsuri, which there is no authentication available by any witness, that transcript will not be presented to the jury. The jury is to determine for themselves what they believe the recording holds. As to any use of transcripts as a demonstrative with the wiretap calls, that will be permitted. As to the use of any transcript relating to Dolce Vita, that will be subject to a proper foundation and authentication being made by the witness. The defense may challenge the foundation and authentication by the witness. However, if the proper foundation is laid at that point, this is no longer guesswork as it relates to the transcript. The parts that are unintelligible cannot be misrepresented in any way. The witness may not misrepresent the parts that are unintelligible. However, to the extent the witness can say, this is what was said during the meeting, that is a proper foundation basis for that testimony, for that evidence to be presented to the jury. That is the ruling as to that item.
Hey, so I think I'm gonna, there's only whatever that says, some minutes left, like 10 minutes left, 11, 12 minutes left of the video of this particular hearing. I've been now streaming like continuously for 6 hours, which that's about it for me. So I think I might call it a day or call it a night for y'all in the US and call it a day for us here in Australia. And I'll probably, Buster, the dogs say yes too. We'll come back and do, the rest of that. And there's a shorter motions hearing, pre-trial motions hearing. Guys, give me 2 seconds. Jeez. We'll do the other one tomorrow night, maybe 11 again, if that's not too late. Guys, God. The dogs are sick of it. I need to go to the bathroom, have some noodles, have some relaxing time. Thank you so much for being here. I hope you were enjoying it, and it's pretty exciting. We're going to be following this trial. I'll do probably daily recaps, nightly recaps. You might not catch the live depending on where you live, and that's fine, but replay crew all the way. Yeah, replay crew is Bay. Mwah! Thank you for being here and your beautiful support and insights and love of the dogs. Love your faces, y'all. I will see you tomorrow from 5:30, 7:30 p.m. Eastern, 11. All I do is stream. Woo! Mwah. Love ya.